The right to the patent shall belong to the inventor or his successor in title. But what happens in the very common case in which the inventor is an employee or a university researcher? Who is entitled to the patent? The answer to this question can only be found in the national laws regulating the disputes about the ownership of a patent. The EPC mainly regulates the grant procedure, and the EPO deems that the applicant is also entitled to exercise the right to a European patent. Referring to the Italian patent law, which is similar to other national European patent laws, in case the invention is carried out by an employee of a private company, and if the invention falls within the field of activity of the company employing him, we can distinguish three situations. A service invention: the inventor is working under a contract which comprises the inventive activity and a special remuneration for it. In this case, the right deriving from the invention goes to the employer, who can file a patent to protect the invention. The employer will be the applicant and, once granted, the owner of the patent. The inventor has the right to be recognized as inventor, but this is a non-transmissible moral right, not a patrimonial one. Company invention: if no special remuneration for the inventive activity is foreseen, but the invention is made within the working activity, the right to the invention goes to the employer, but in case the employer obtains a patent, the inventor is entitled to obtain an equitable prize. Different methods have been proposed to reckon the equitable prize. Very often, a reference is made to the so-called German formula I = V times P, where I is the equitable price, which should be recognized to the inventor, V is the value of the invention, corresponding to how much the company should pay for buying the right to use the invention in case the invention was protected by a patent. P is a percentage factor which is determined on the base of three indexes: the autonomy of the inventor in solving the technical problem and conceiving the invention, the contribution given by the company, the level of the task of the employee. The third situation is the so-called occasional invention. If the invention is occasionally obtained by an employee normally performing a different task, but the invention falls within the scope of the activity of the company, the inventor can file a patent application under his name, but the employer has an option to use the invention to acquire the patent and to extend it abroad, paying a sum which must be determined, also considering the help received from the company in obtaining the invention. If an employee resigns from his job and files a patent application, the former employer maintains his rights for 1 year after the resignation. In the Italian patent law, contrary to other national European legislations, the university researcher or an employee working in a public institution making research is treated differently from the employee working in a private company. The university researcher who makes an invention has the right to file a patent, and he becomes the owner of the patent. This right is not transferred to the university or to the public institution employing him or her. In case the patent is licensed to a third party and a royalty is obtained, part of this royalty goes to the university and part goes to the owner of the patent. The university should establish a rule on how the royalty should be split, but not less than 50% of the royalty should go to the researcher. If the university establishes no rule, 30% of the royalty goes to the university. This provision does not apply if the research is financed by a private company or institution, or a public institution or a university different from that where the researcher is employed.